Okay, good morning or good afternoon, everyone, depending on where you are in Australia. My name is Joel Comfort, and I will be your host today. Protecting your intellectual property will be the focus of today's session. Joining me today and steering this vessel will be Damin Murdock, our principal lawyer here over at Lawpath. For those who don't know Damien, he has been practicing for decades and has extensive experience within this field, representing a number of high-profile IP cases in particular. He has a 5 out of 5 star rating out of over 300 reviews on our Meet the Lawyers website page. There you can see our lawyers who speak to our legal advice plan clients, and they cover a broad range of legal areas in commercial, employment, startup, and a plethora of others. Now, intellectual property. Intellectual property, or IP, is one of the top legal concerns for small business owners, whether it's securing trademarks and patents, dealing with infringements, or ensuring contracts include the right protections. Damien will walk you through the key steps to safeguarding your IP, which grants you exclusive rights to your creations and innovations. If you haven't had a one-on-one discussion about this, whether you're launching or growing a business, then hopefully this webinar is your opportunity to gain as much clarity as possible. Failing to protect your IP can lead to serious challenges, as seen in high-profile cases like the Facebook's early legal battles. Unlike big corporations with large legal teams, small businesses feel the impact even more, making proactive protection essential, especially in regards to IP. For those new to Lawpath, we are Australia's leading online legal platform, supporting over 500,000 businesses in the past decade. Our affordable subscription model eliminates costly legal fees, providing unlimited legal and accounting support that is 100% tax deductible. In total, we've saved Australian businesses over 100 million in legal fees. We'll wrap up with a Q&A session later on today, so stay tuned should you have any questions. And please submit your questions in the dedicated Q&A chat box, which will be displayed shortly. Now, let's go ahead and dive in. Please take it away, Damon.
Perfect. Thank you very much. Hello, everybody. Welcome to our session today. As mentioned, ideally, drop your questions in the Q&A. It's normally the most valuable part of the presentation. I'm not sure if the Q&A is opened up, so maybe we can see if that is. If it doesn't open up, then we can drop it into the chat. But ideally, if you have any questions, feel free to drop them in, and we'll deal with them at the end. So to begin with what is intellectual property? Generally, intellectual property is something generally not tangible. It's not a brick. It's something that you can't necessarily feel, and it's like your name, your business name, your trademark, your logo, your design, your patent, things like that. Now, what people we get this all the time. People say, "Oh, I cannot believe it. I've just been able to register my company ABC Plumbing, Pty Ltd. I can't believe that was available." And then they get really excited because they've just been able to get a company name that they really, really wanted. But what's interesting is that that doesn't give you any protection at all, really. Just because you were able to get a business name or incorporate a company with the name that you wanted doesn't mean that there isn't another company out there that is operating under the same name and has a trademark already. So ASIC, when you register a business, all that does is allow you to create a company with a specific name, and no one else can create a company with the identical name. So for instance, we have Lawpath Operations. You could come along and create a company called Lawpath Services or Lawpath Incorporated or Lawpath Trading Co. or Lawpath, whatever. Just because we have a company registered, it only stops someone from incorporating the identical name. The way you actually protect yourself is by way of a trademark, and we'll get into that later. So it's really important to know that just because you have a company name doesn't mean you have any kind of protection at all. Now, the different kinds of intellectual property we normally talk about, we have copyright. So that's your story, that's your music, that's the content on your website, that's your book. A trademark, that is your brand. So it's normally your name, your product name, your logo, your slogan, things like that. And then we have the design. So the Omo bottle, for instance, or some of the packaging that you see in the market, like the Coca-Cola bottle, might be a registered design. And then you have patents, and patents are normally something that's a little bit more scientific. And this is a little bit confusing, so I'll tell you that now. When you look at patents, in America, we call lawyers attorneys, and and attorneys can mean lawyers, but they can also mean patent attorneys. So here in Australia, a patent attorney is not a lawyer. A patent attorney is somebody who has done a scientific degree and then did a master's to become a patent attorney. So, for instance, if you are doing a computer program, let's say some kind of AI program that you're developing, and you want to see whether you can get a patent, you don't call a lawyer because we don't know how to draw your patent. A patent attorney is someone that has normally a computer science degree, and then they will then help you with your patent. Same thing if you're creating a chemical or a drug of some sort, then you would call a patent attorney that has a chemistry degree as its scientific degree in the background. So lawyers don't do patents, but what we do is we enforce patents in court. But if you are looking to get a patent, look to a patent attorney, not to a lawyer. Now, what we touched upon this briefly, but let's talk about the Zuckerberg problem generally. So it's really important as at first instance to know the general law. And the general law is that if you have an employee who works in your business and they invent something or create something as part of their employment responsibilities and duties during using your computers, then normally that intellectual property is owned by the employer. And that's automatic because that's under case law. But if you hire a contractor to do something for you, it is automatically owned by the contractor, not by you. Which means that if you were to hire a contractor to do anything for you, they own it unless you have a contract that says otherwise. There's no such thing as an implied transfer of intellectual property unless it's between employee and employer. So if you hired someone to go and draw up a logo for you, they own that logo. And if you hired someone to go and make a website for you, they own that website. And the only way for you to own it is if you have a contract in place saying that they have an obligation to assign, transfer, or that upon creation, it automatically is owned by you. So this is where we get to the moonlighting problem and then the Zuckerberg problem. So if you look at the moonlighting problem, that's where employees might work in an existing business. They come up with an idea because they see the gaps that their employer has, and they say, this is perfect. I'm going to start making this. And then once I get it to market and start making a little bit of revenue, I'll quit my job as an employee and I'll go off and start my own company. Now, the problem is that because you came up with that idea, you might have been working on that idea while you were employed somewhere else, and you might have used your employer's confidential information or intellectual property in the creation of that idea as well. It means that your employer might be able to sue you claiming ownership of it. So if you are planning on creating something while you're employed somewhere, you have to be very careful. And there's very detailed is going to be the employees or whether it's the employers. And it normally looks at whether the invention was created by use of the employer's intellectual property and confidential information, whether the invention arose during the performance of the employee's roles and responsibilities for that employer, or whether they use the resources of the employer, such as the time Monday to Friday, 9 to 5, or their computers or their IP and confidentiality to determine whether the employer owns it or not. So again, it's important to note that if you are an employee looking to start a new business, you got to be very, very careful that that new business isn't going to be invading on the intellectual property that's automatically owned by the employer. On the counter side, if you're a contractor, you have the Zuckerberg issue where Zuckerberg was hired not as an employee, but hired as a contractor to develop Connect You. And ultimately, he decided, well, I really like that idea. I'm going to keep it for myself. And because there was no written contract, Zuckerberg automatically owned that intellectual property. So that's the two issues identified in this slide. Now let's look at copyright. Copyright, unlike the United States, it's automatic. It doesn't need to be registered anywhere. You'll automatically own it when it comes into existence. So if you were to draw a picture, write a book, take a picture or a photograph of something, write music, and do code for a computer program, that is automatically brought into existence. You don't need to register it anywhere. But when you sue to enforce copyright, you have to prove that you are the author or the creator of that work, or you might be the employer and an employee had created the copyright for you. So you got to prove the ownership. So back in the day, what they used to do is people used to draw up a plan and then they would put it into an envelope. They would post it off to themselves, and Australia Post would stamp it with an Australia Post stamp with the date of creation, and then they would put that on the side so that if at any time they had to prove that they actually owned it, they would have an actual record of the date that they mailed it to themselves to prove the ownership of it and the date that it came into existence. And you see this a lot in different musicians suing each other because they're saying, "Oh, well, they have copied the song from 1956," and the songwriter now says, "I've never heard of that song. I have no idea." Um, but and so that goes into a different area of law. But you see that where people are saying, "Oh, well, they ripped this piece of the music." And now they've made millions of dollars. We're going to sue them for copyright infringement because they've taken a piece of our original works and they have copied it to make their new piece of works. And so copyright infringement is the copying of a substantial part of originating works. So for copyright to exist, it has to be innovative, it has to be new, it has to be an expression of an idea, an original. And then for someone to infringe upon the copyright, they have to copy a substantial portion of that for it to be deemed an infringement of copyright. And if once you can prove that you own it, it was original and an expression of an idea, and someone has copied it in substantial form, you can then sue for damages, which is effectively, so for instance, if you had a computer software and someone cracked into your software and use it, you can sue them for damages being the license fee of what you would have charged, or you can sue for account for profit. So if someone's taken your data and have made profits off of it, you can usurp the profits from the person that's used it and get all those profits from them. And so that's the benefit of a copyright, the legislation, because it allows for damages and it also allows for count for profits. And you see that a lot in the food industry where people are, you might have Hungry Jacks and then they might have another restaurant called Hungry Jacks or something slightly different that looks different, but ultimately it's effectively the same. So that's copyright generally. Now there are defenses to copyright, and one's called the innocent infringer defense, and that's where someone says, "Well, I didn't know I was infringing it, and the minute you told me to stop, I did stop." So Copyright Act is the governing law. There's no way to actually register it, and it is the infringing of it is the copying of the original work. And so some things to think about is if you are creating, let's say you're an engineer or an architect and you have designed plans and drawings, you want to put the little C in the bottom of it, or if you have a book or anything like that, you put a C. And the reason why you have that C, where it says, for instance, under number 2, Mary Smith, is that that's to prevent the innocent infringer defense. That's so that someone doesn't say, "Oh, I didn't know." So on the internet, you might see a photograph and it has a watermark where it might have someone's watermark across it. And if you go and take that image and then you use your iPhone to remove that image, then you will probably be, it'll be very difficult for you to be able to claim an innocent infringer because the only one that's available in the public domain is one that has a watermark and you've removed that watermark. So if you're creating copyright, you want to have that little C so people know that it is copyright protected. Now, something else is that copyright laws change country from country. So if you are operating in the United States, you can register the copyright as well, and you can get a certificate for the date that you registered it so that you can prove the date that it actually came into existence or you started using it and protecting it in the United States. Now, trademarks totally different. We have with trademarks, as I mentioned, that's a specific word, letter, number, slogan, image, such as your logo, things like that. And that is registered in Australia through IP Australia. And if you register a trademark in Australia, and once it becomes registered, you can use that as what's called the priority date, meaning the date that it's registered here. You can then go and use what's called the Madrid Protocol, which is with the United Nations World Trade Organization, to register your trademark in multiple countries around the world. And when you go and do that registration, it takes the priority date from Australia as if it was the date that's registered in all the other countries around the world. So you don't necessarily need to use the Madrid Protocol if you want to get trademarks all around the world, but if you want to make sure that you get to use the date that you first registered it in the other countries that you register, you want to go through the Madrid Protocol. Now, what is a trademark? How do you register it? So a trademark, it protects your brand, your slogan, your number, whatever it might be, in a particular class. So for instance, if you are in business services, then you want to register the trademark in the class of business services. And what it does is it stops anyone else operating in business services from using that trademark. But it doesn't stop somebody from using that word in, let's say, alcoholic beverages or in computer applications, because that's a different class. So if you were creating a computer program and you created a brand and you register it in that class relating to computer scientific programs, you will stop anyone else creating a program with that same name. But if you wanted to start making merchandise like t-shirts and bags and things like that, and because you go viral and it becomes trendy, if you don't have a trademark in merchandise class, then someone else can pop in and start trading with that logo of shirts, for instance, in the merchandise class, because normally the first to register has priority. So you want to look which class you want to register your trademark in and how many classes do you want to register, and each one's a separate application depending on how many different industries, I guess, you are operating in. And it's not uncommon. I use the example normally barefoot. There's a barefoot shoes and there's a barefoot alcoholic beverage. And they have had a dispute in the past because they both registered their trademarks, but they slowly started to integrate into merchandise. And that's where it became an issue because neither of them had merchandise class for their trademarks. So that's that. Now, to get a trademark, it has to be unique and distinctive. So if you came along and said number one taxi, that's not unique or distinctive because all it is a description of the services that you are using. And what it does is it would, if they were to allow the registration number one taxi, it means that no one else would be able to use number one and taxi together. So you could be the number one taxi in Wagga Wagga, but if someone else had number one taxi, that means that you wouldn't be able to use it nationwide, which is not the intention. And that's why trademarks have to be unique, distinctive, and not identical to anything else and not similar. And you'll see different companies are spelling words differently. So you might have, I'm trying to think, I don't want to use a particular client's example, but you see the word unique and someone might spell it UNIQ and drop the U and the E. Just because you do that doesn't necessarily mean it's unique, distinctive, and it doesn't mean it's identical to someone else, because unique can be still, it still could be deceptively similar just because you spelt it differently. So a lot of the times what people will do is do what's called the Head Start application. And that's basically saying, before I pay the full fee to get my application processed by IP Australia, what I'll do is I'll ask an examiner at IP Australia whether they think that my trademark looks like it might be unique and distinctive enough. So you can pay about $250. You can file your application. Someone at IP Australia will look at it and say, no, I think you're going to have an issue. We've searched the database and these are the issues that you have. Try again. Or they'll come back and say, yep, as a preliminary search, it looks fine. You can go ahead with your application. So those are just a couple of steps that you might want to consider when you come up with your business name, or at the very beginning. You might just start off with something that's not unique, not distinctive, and it's identical to someone else. And you might put a lot of money into marketing and developing it and buying domain names and building a website and getting all your merchandise and everything. And then only to find out that 6 months down the line, you do a search with IP Australia and you see someone else in Australia has the exact same name, doing the exact same industry. You're going to have to now rebrand, because if you don't, they can stop you at any time and get an injunction against you to force you to change your name and transfer over possibly the ownership of some of the business names and things like that. So before you go down the avenue of spending a lot of money on the marketing and branding of your company, go to the IP Australia website, do a search on the website to see if there's any other trademarks that are similar. Do a search under the ABN lookup, see if there's any other business names. Do an ASIC search, see if there's any other companies with a similar name to yours, and do a Google search to see whether there is anybody similar than yours. And if they are similar, check IP Australia, see if they've registered a trademark. If so, see what class they're in, because they might be in a totally different industry to you. So those are the main aspects of your trademarks. Now, a trade secret is copyright. A lot of people won't get a patent on a trade secret, because when you get a patent, you have to disclose your secret. So a lot of times it comes down to protecting your trade secret, which is confidential information and copyright protected material. But to protect your trade secret, you need to be very, very careful. So a lot of times people say, oh, I'm going to enter into an agreement with these people that I'm going to do business with. I'm going to do a non-disclosure agreement or a NDA, and then I'm going to spill my beans and tell them my trade secrets. Now, an NDA doesn't necessarily protect you. And the reason why it doesn't necessarily protect you is that there's something called the Berne Convention, and it basically says that copyright only protects an expression of an idea. And an expression of an idea is normally something that's expressed in writing. So if you have an idea and you just express it verbally, you normally aren't going to be able to protect it, because you actually have to draw the picture, write it on a paper, create that copyright material. And so I guess the best example of this is there's an Ali G TV show where Ali G creates the hoverboard, and the company that he approaches says, well, that's great. You've created the hoverboard, which is a great invention, but how do you do it? And he says, I don't know. That's your problem. The expression of the idea, or just creation of an idea, isn't protectable, because it has to be how you actually do it, and drawing the plans and the drawings and the diagram of how you're actually going to do it, which is protected. So that goes back to your NDA that you might sign with someone. You might go and say, okay, look, I'm entering into a government contract. I need to hire you for this. This is the price that I've gone into. These are my clients that are going to work with me, and this is what we're going to do. That you might not be able to protect any of that, because one, they can go and find that material in the public domain themselves. So they might not use the information you use from the meeting, even though they've signed an NDA. That only protects the confidential information that you shared during the meeting. But they could go to that government website and find that tender document. They could go to your website and see that you're partnered with all these clients and say, well, that's in the public domain, so now I can approach them. So we always say if you're going to do an NDA, do not disclose your trade secrets. Do not disclose the name of your actual clients, the name of the customers, things like that. And if you are or you need to disclose that, you should have some kind of non-compete clause in there that says that they're not going to compete against you. So not just an NDA. And if you talk to most barristers, they'll say that a non-disclosure agreement's not really worth the paper it's written on because it's normally based on conversation. So if you're going to share confidential information, rather than verbally telling them, you should probably have a paper trail as well and have an agenda saying, okay, this is what I'm going to disclose to you, or here's what I'm giving. But you always want to withhold some of the information because you don't want to give away as everything so that they can go and do it themselves. Now, when we look at the Coca-Cola bottle, so some of the lessons that we've learned, so Coca-Cola, we have the brand is being trademarked, the shape of the bottle has been patented, the recipe is a secret. And that's just an example putting it all together. Now, when we want to just protect your IP generally, the first thing is you want to look and say, well, what IP do I have? What IP might I have? How do I protect it? So you've got to look at number one, what am I creating? Do I have an idea that might be patentable? Well, if you share that idea with the general public, that patent is no longer able to be protected because a patent only applies to things that haven't actually been commercialized yet, but will be commercialized in the future. So you can't put the drawings or specifications of exactly what your patented idea is into the public because if it's now general knowledge, you can't be protected. So first you got to look at, is it patentable? If so, I need to talk to a patent attorney. Am I creating software? If so, am I hiring contractors or am I hiring employees? If I'm hiring a contractor, I need a contractor's agreement that specifically specifies that the intellectual property is owned by me. Am I hiring a website developer or a third-party company to develop it? If so, I need a software development agreement. I need ownership of the intellectual property. I need a confidentiality clause regarding your plans, processes, systems, and clients and customers. I need a non-solicitation clause in my employment contract, in my contractor's agreement, and in my services agreement that says that I'm going to be sharing confidential information. I'm going to be sharing intellectual property. Our intellectual property is owned by us, and you must not approach our clients, our partners, our customers, and so on to solicit work away from them in competition to our business. And if you do, then we can get an injunction to stop you, or we can sue you for damages for the lost revenue that we have as a result of your solicitation of our clients in breach of your non-solicitation clause. You also want to consider whether you want to have a non-compete clause. So a lot of times if you have senior executives who know the ins and outs of your business, you don't want them to start a competitive business. So you want a non-compete clause. And a lot of times people say, oh, well, non-compete clauses aren't enforceable. That's BS. They are enforceable. And the enforceability of those clauses are in the Supreme Court of most states regularly. The reality, though, is that they can't be too far reaching. They have to be for a limited period of time. They have to be for a specific purpose and within a certain geographical location, but they are enforceable. And so you want to have them if they deem necessary. Other things to consider is what to share and when to share it and who to share it with. So these are some of the things that you want to start creating a system to protect your intellectual property. And whether it's going to be copyright, trademark, patent, or trade secret, then you need to consider confidentiality, intellectual property, non-competition, non-solicitation clauses, all within your contracts. So we mentioned one of the ways is to have an NDA. Non-disclosure agreement is good as I have initial discussions, but it doesn't protect just simply telling somebody all your trade secrets during a meeting. And you always want to hold back on the specifics until after you've signed up your commercial agreement. And it might be the case that you actually don't know what that commercial agreement is going to look like. You might be hiring a company that's going to develop a website or software for you, and you want to give them as much information as you can under the NDA, but you don't want to share all your secrets. So you can always just enter into a simple services agreement and says, we're going to share our intellectual property with you. You're going to formulate and design an architectural plan for our software for us, or a design proposal for us for $1,000 or something like that. Something simple, which means the minute you share the information with them, they have a positive obligation to share their plan and infrastructure with you, maybe for $1,000. You own that, what they've developed, and you have a specific contract in place dealing with it. So that's just something else that you can consider as the next step after the NDA. Going back to patents, as I mentioned it, they have different fields of specialization. Patent attorneys have different fields of specialization. And when we look at patents, generally, you don't go to lawyers for it. But what is it? It has to be innovative. It has to be new. It has to be capable of being commercialized, and it can't be disclosed to the public. And patents are also registered with IP Australia. So when you look at intellectual property, designs, patents, trademarks are all registered with IP Australia. They all have a different time of enforcement and protection. Copyright is not. And so if we look at designs and how they're a little bit different, so design example again is a logo brick, the shape, the KitKat bar, things like that. Those are designs, and you can protect those. And yeah, another thing is jewelry and the shape of the design of the jewelry. So specific industries are much more common using designs than other industries, like engineering as well. So those are some things to look at. And when you want to look at whether you can register a design, there has to be a drawing, so specifications in terms of what it actually is. You get protection for up to 10 years, stopping anyone else from recreating it. And then you get a certificate that protects it. Now, just because you have a patent that's been registered, or a design that's registered, or a trademark that's registered, or a copyright, the next step is enforcing it. And the enforceability is hard because it's generally quite costly, because you have to go to a lawyer. That lawyer oftentimes will hire a barrister. And because intellectual property law is generally covered by a federal law, means you're either going to the Federal Circuit Court, or the Federal Court of Australia, or the Supreme Court in your state. And because of that, it means that the costs will generally be higher, because it's an area of law that normally a local solicitor won't be able to do in the local court. And so the normal process to enforcing it is you identify what the infringement is, you send a letter of demand, you explain your ownership, you explain the registration of your registered trademark or patent or design, and you demand that they cease and desist using it. If it's copyright, you explain what the infringement was, how it's being infringed, and you can demand that they cease and desist using it. And if they do not respond, then you can proceed to court. Now, oftentimes in a cease and desist letter, they'll also say, we will forgive you. We've caught you though. We will forgive you now, but you sign an undertaking that you'll never do it again. You deliver up everything that you've done. You tell us who you've disclosed this to, where you've used it. Give us a copy of your profits that you made, and then we'll stop. And if you sign this undertaking, and if you don't sign this undertaking, we're going to go to court and we're going to sue you. And when you sue, you can sue for damages. There's various different kinds of damages. In copyright, if you have a computer program that has codes, like a key and a lock system, it's called the technological protection measure. Someone infringes that, you can get aggravated damages, so additional damages on top. You can get normal damages, which is like the license fees of a photograph or license fees of computer software. You can get nominal damages, which is just saying, just give us a decision that says we're in the right, they're in the wrong, and pay our legal costs. You can get exemplary damages potentially if they've done it over and over and over again. You can get account for profits, which is taking all the profits away from them, and and you can sue them on top of infringing your intellectual property. You can also sue them for misleading and deceptive conduct as well. So those are the from the start to the finish of what it is and to how to enforce it. And if you have any questions, drop them in the chat box now. I'm going to go back to Joel, and Joel will talk to you a little bit about how Lawpath can help. And then what we'll do is we'll come back here for some Q&A. Thank you.
Thank you very much for that illuminating presentation, Damon. As always, your wisdom is supremely valuable. So thank you so much for that. I will keep this brief for everyone. I know we've probably all got to get back to work, or everyone wants to have a belated lunch, late lunch break. So essentially, in regards to our plans at Lawpath, our legal advice plan and essentials plan are perfect solutions for business owners looking to protect their intellectual property, whether it's trademarks, copyrights, or even patents. With unlimited legal consultations and access to over 500 plus legal templates, you'll have expert guidance to secure your business assets, essentially. Plus, with our new bundle feature, you can get 40% off when you're combining our legal, accounting, and tax plans, ensuring complete protection and financial compliance as you grow within your business or expand out, whatever path you choose to take. There is never a better time than now to safeguard your business with Lawpath. So if this is something that's kind of niggling or at the back of your mind, even just giving us a call and having a conversation about it, we're more than happy to just give you our honest feedback. And if we can determine that maybe now isn't the best time, then certainly we might recommend a later date. But if it's something you're going to be expediting and moving forward, then certainly we may recommend hopping on one of these plans sooner rather than later. If you do wish to delve deeper into IP for your own business and you are on the legal advice plan, you can book through your consultation portal and speak to someone as soon as tomorrow. If you're meeting us for the first time, we can supply your business with unlimited legal documentation with unlimited edits and versions. And through our contract management system, you can complete professionally drafted templates within 5 or 20 minutes. We have built the platform so that you can confidently DIY a lot of your legal work yourself without spending the expense on contract drafting from lawyers or spending up to $600 for an hour's consultation with a lawyer for advice. I should also mention as well that we have a free trademark service offer for the first 5 people who do sign up for the legal advice plan today. And this will all be available for you to observe within the email that I send over. And yeah, look, if you are interested, please reply in capital YES, yes, in the chat for a callback or a demo, or even a webinar recording will be on YouTube. As I mentioned in the chat, if anyone's new here, every single one of our webinar sessions are uploaded to YouTube if you have to duck out or if you can't make it or if you come a bit later. Hopefully we try to get it in the afternoon after around 3 o'clock, but otherwise it'll always be uploaded to YouTube a day or two later on.